Barbara's here.
Good evening and welcome to the Judicial Candidates Forum sponsored by the Lackawanna County Democratic Federation of Women. I would like to formally introduce the judicial candidates who are with us here this evening and who are running for a seat on the Lackawanna County Court of Common Pleas and are asking for your vote on the May 21st primary election. It is my understanding that all the candidates here this evening have cross-filed and will be on both the Democratic and Republican primary tickets. We have first Attorney Alice Hailstone Farrell, Attorney James A. Gibbons, Attorney P. Timothy Kelly, and Attorney Patty Grande Reeder. Welcome and thank you for giving your time this evening. All judges of our county courts, whether they are initially appointed by our governor or elected by the people, serve for a period of 10 years and must periodically run for re-election. Voters need to know whether a candidate has the essential qualities to be a good judge: integrity, knowledge of the law, intelligence and common sense, freedom from bias to apply the law fairly, and the ability to make decisions in a timely manner, and the personal skills to preside over a courtroom with dignity and courtesy to all participants. It is also important for voters and the audience this evening to understand that the Judicial Code of Ethics limits judicial candidates' discussions of certain subjects. They are precluded from discussing their views on pending cases or disputed legal and political issues. They are equally precluded from making any pledges or promises to the voters or the audience this evening other than the faithful and impartial performance of their judicial duties. With that premise in mind, I have prepared a list of 5 questions for use during tonight's forum. Each candidate will be given a 2 to 3 minute opportunity to respond, and we will start in alphabetical order. Our first question, and I would direct it to our first candidate, Attorney Alice Hailstone Farrell. I would like all judicial candidates to take this opportunity to briefly introduce themselves to our audience and to outline and discuss for us this evening your legal experience, your community and volunteer activities, your interests, and the reasons why you have chosen to run for a judicial seat at this time. Alice?
Thank you, Judy. Thank you, everyone, for coming this evening. As Judy said, I am Alice Hailstone Farrell. I am a magisterial district judge, currently in my 16th year in office for the area serving East Scranton and Central City Scranton. In those 16 years, I have handled over 130,000 cases in my office. And they range from everything from parking tickets to murder cases. I have handled civil matters, landlord-tenant disputes, small claims matters such as contract disputes, car accident cases. I have also handled all criminal matters from the ground level up. That means search warrants, arrest warrants, preliminary hearings, arraignments. I also handle all small matters like non-traffic cases. That would be things like public drunkenness, underage drinking, and then your traffic matters, going through red lights, parking tickets. In the time that I've been in office, I have worked hard to form programs to help young people who need help, who need a second chance. I have always been the pilot office when there's a new program to be tested in the county. I have the University of Scranton in my jurisdiction, so we started an underage drinking program to give first-time underage drinkers a second chance. We also have, in my office, a first-time offender retail theft program that I work with the counseling program at the University of Scranton to give first-time offenders for retail theft a second chance. Now, don't get me wrong, I am not soft on crime. I am the only candidate who has been endorsed by law enforcement. I've received the endorsements of the Pennsylvania State Police as well as the Scranton and Dunmore Police. They say I'm tough on crime. I show up and I do my job when they need me to, which sometimes is 3 o'clock in the morning. I am asking for your vote for the Court of Common Pleas because I think I have more to offer. I've been on the front lines of the minor judiciary for these 16 years and would like an opportunity to move up to the trial level where the issues are a little bit bigger and there's more that I can do. Thank you.
Thank you. Attorney Gibbons?
Thank you, Judy. Thank you and welcome, everyone. Thank you for this opportunity to come and address you this evening. Like Alice, I am also a magisterial district judge. My jurisdiction encompasses what's generally referred to as the Abingtons. I have 11 municipalities in the Clarks Summit and Clarks Green area. I am in my 31st year as a lawyer. I graduated from law school 31 years ago. During that time, I've served in a number of different capacities. In addition to being a magisterial district judge for the last 8 years, I've also been a federal prosecutor for 6 years. From 1987 to 1993, I was an assistant United States attorney here in Scranton. I'm the only candidate running for judge that has any prosecutorial experience at all. In addition, I've also been a practicing attorney and handling all types of civil and criminal cases in both the state and federal courts over the last 31 years. All the types of cases that a common pleas judge sees on a regular basis. I've tried cases in front of common pleas judges, criminal cases, civil cases, the very cases that I would be handling as a judge. Additionally, in 2009, I had the privilege to be appointed to the statewide commission that investigated the wrongdoings in the juvenile court in Luzerne County. I served with a number of distinguished judges and prosecutors and juvenile probation officers and victims' rights advocates from around the state. And I was the only judge from northeastern Pennsylvania that was appointed to that commission. And one of the things I learned in that experience was what great faith people have in our justice system. And in thinking about that and reflecting on that in making my decision to run for common pleas, I sensed that because of what's happened locally here in northeastern Pennsylvania over the last several years, there needs to be an effort to restore the faith of the people in our judicial system. And I think I'm poised to be able to do that. I thank you for your time. I look forward to talking with you throughout the evening.
Thank you, Attorney. Attorney Tim Kelly.
Thank you, Judy. And I thank you all for inviting me here tonight and sharing a wonderful dinner with me. My name's Tim Kelly, and I've also been practicing for 31 years. My practice is located in Scranton. However, I practice in all the counties of northeastern Pennsylvania and also in the U.S. District Court for the Middle District of Pennsylvania. My practice is a trial practice. For those 31 years, I've represented citizens of northeastern Pennsylvania in various civil matters before the various courts of common pleas and also in front of the U.S. District Court. Civil matters involving accidents and injuries, civil matters involving commercial litigation, civil matters involving fraud claims. I also work in administrative tribunals. I work in the workers' compensation system. I work in the Social Security system. I practice in Scranton with the firm of Mattice & Kelly, and my partner and I have run that firm since 1999. It's actually just about an even 14 years now that we've been in business for ourselves. We look at that as running a small business, and I think in order to be a judge, you should also, in addition to being simply a lawyer and understanding the court system, you should understand how a business runs. As far as the court system is concerned, my practice in the court system has allowed me to see how cases are handled, how to operate a case, how to run a case. I feel that I have more experience than anybody else running for judge in that field. I understand courtroom etiquette. I understand how cases have to move through the system. I think one of the greatest failings of our current system is the delay in moving civil matters through the system. In addition to civil matters, I also have practiced in criminal court, both in the federal system and in the state system. Outside of the law business, I have several interests in several activities and things I've participated in the community. I'm currently the president of Lordsmont. I'm a past president of the Voluntary Action Center and currently serve on the board of the Voluntary Action Center. My wife and I founded Timmy's Town Center, and that's operated in the Steamtown Mall. And in the last year, we served, slightly under 10,000 paying guests through Timmy's Town Center. And that's something that we got involved with several years ago after a son of ours had passed away. In the legal field, I'm a member of the American Board of Trial Advocates. I'm also have been elected to the Board of Governors of the Pennsylvania Association for Justice and have been re-elected to that Board of Governors since 1997 and currently serve on that Board of Directors. I feel that my experience in the legal field, both civil and criminal, my activities, my participation in community events, and also the various organizations I belong to have uniquely qualified me to serve as a judge and to serve the people of Lackawanna County in that position. I ask for your vote, and I again thank you for allowing me to come here tonight.
Thank you, Attorney. Attorney Reeder?
Thank you, Judy, and thank you to the Lackawanna County Federation of Democratic Women for the opportunity to speak to you tonight and allow all of us to get our message out. I'm delighted to be here this evening. As Judy indicated, my name is Patty Grandy Reeder, and I too am running for judge in Lackawanna County. I graduated from law school in 1991. I attended Catholic University Law School. Upon completion of law school, I received a federal clerkship with Richard P. Conboy, who at the time was the Chief Judge of the Middle District of Pennsylvania. Upon completing my time with Judge Conboy, I received a position as an associate with a very large law firm by the name of Schneider, Harrison, Siegel, and Lewis, and I was assigned to their litigation department. While there, working in corporate litigation, I received a call from Tom Vanaski, who was a newly appointed federal judge. He asked if I would consider returning back to the federal court to work in his office. I accepted, and I worked under Tom Vanaski, who is now a Third Circuit Court of Appeals judge. Upon completing my time with Judge Vanaski, I began my own private practice and did that for several years until about 5.5 years ago I received a call from the President Judge of Lackawanna County. He asked if I would be interested in coming back to the court system to serve as a special hearing master, to preside over cases, particularly in family court, independency hearings, dealing with children who are suspected of being abused and or neglected. He also asked if I would preside over orphans court hearings, which deals with wills and estates, and guardianship hearings for elderly individuals who are suspected of being perhaps abused or neglected. I also presided over a criminal court called status court, dealing with juvenile offenders who have committed minor criminal offenses. And that experience, sitting on the bench for the last 5.5 years, presiding over cases, many of which the new judge who will take the new seat will preside over, those very same type of cases. That's what makes me uniquely qualified, because I've been doing that job on the county bench for the last 5.5 years. And that's what I bring to the table. Experience doing the job for the last 5.5 years. Thank you.
Thank you very much. Jim Givens will have the first question. And to all the candidates, I'll address this question, and then we'll go with Jim, and we'll pass the microphone on to each candidate. Across our country and here in Lackawanna County, violent crime, the use of illegal drugs and prescriptions, and internet crime, particularly amongst our juvenile population, is perceived by some to be at a crisis level. What role, if any, do you believe the judiciary has in addressing this perceived crisis in our criminal justice system?
Thank you, Judy. Well, I have played a role as a district judge in the Abingtons. I work hand in hand with the law enforcement community, all the police departments up in the Abingtons, and our school district, the Abington Heights School District. And we have, over the years, during my 8 years as magistrate, put on a number of different programs dealing with drugs, internet crime. We've had people from the Internet Crime Task Force, the statewide task force, come and make presentations, not only to the students in the classrooms, but also to parents. And we've had a lot of successful programs like that. We've been dealing with that. We've been dealing with drugs. We've been dealing with underage drinking on a regular basis over the years. So I think, you know, from an educational standpoint, the judiciary can play a tremendous role in getting the message out from that standpoint, and I've been doing that. As a judge, you know, you can still participate in general educational programs like that within your community and with it, throughout the county. And there are innovative ways, too, as a judge, to address those problems. We now have not only in juvenile court, but we have specialty courts here in Lackawanna County. Judge Mike Barrace has been a leader in the development of those courts. And so judges can take a very, very active role, not only in a judicial capacity, but also in an educational capacity.
Very good. Thank you very much. Attorney Kelly?
These are new crimes, and they're certainly a concern in the community. Because they're new, because they're not things that we've seen in the past, there's a fear of them. And I echo Jim's comments. A judge can be proactive. The day of the judge presiding and throwing someone in jail and throwing away the key are gone. A judge has an ability to get into the community through the various courts and rehabilitation programs offered through the court system to work with individuals who come into the system who are accused of crimes involving drugs, crimes involving the internet. You can use the criminal justice system to educate these individuals, to educate their parents, educate the individuals they deal with on a daily basis in the schools. It's something that we have to be proactive with. It's not something that we can simply sit back and react to as we did in days gone by. The judge has the ability, as someone there on the front lines, to be intimately involved in the programs necessary in order to curb this type of behavior and to prevent children from becoming involved in it in the future. And that really should be the goal of the judge and also the judge's support staff, is to educate and dissuade children and younger people from getting involved in these types of crimes in the future. Let's face it, if they get involved in internet crimes, drug crimes, oftentimes if it's not handled and nipped in the bud, that child can become even a more serious criminal in the future. So the judge has to be very proactive, the judge's staff has to be very proactive, the court system itself has to be very proactive, and attempt to head off this type of behavior and re-educate, retrain, and simply to put that individual back into the community as someone who now understands what he or she had done and will work to be a better person in the future.
Thank you. Attorney Reeder?
Thank you. I, too, have had an opportunity to play a role as a special hearing master presiding over status court. One of my first responsibilities when I assumed that position was to help develop and implement status court, which, like I said, deals with juveniles who have committed minor criminal offenses. Immediately, when you start presiding over those type of cases, you notice some trends. And we are noticing that technology, although it's a great invention, is playing a larger role in juveniles. Unlimited access to technology, things like the internet, and unsupervised access. And we know that when children have unsupervised access to technology, they have a tendency to not use it in their best interest. We also see a rise of juveniles presenting with a dual diagnosis, mental illness as well as a drug addiction. And when they present with the dual diagnosis, it's much more difficult to assist the juvenile and the family in overcoming their issues. We also see on the county bench a shift in cultural norms, not only in Lackawanna County, but probably the nation as a whole, where illegal substances are more readily available and acceptance of those illegal substances is more prevalent. So what we did with status court is we said we're going to try to focus on capturing children between the ages of 9 to 14. Because we looked at this issue and we said children between the ages of 9 to 14 have the most potential for correction. So we developed status court to target those juveniles between the ages of 9 to 14. And we said the best way we can help individuals who are suffering from addiction or mental illness is to do weekly reviews. Not reviews every 90 days or every 6 months, but weekly reviews so we can stay on top of the illness, we can stay on top of the addiction. Because we all know that relapse at times is a part of the recovery system. So those are some of the things that as a member of the judiciary we can do. We can educate ourselves and target those individuals that we can have the most success with. And we can do weekly reviews so we stay on top of the issues and bring that family through the system much quicker.
Thank you very much.
Thank you.
Okay. Attorney Farrell?
As a judge for the last 16 years, I have watched how children have gotten into more and more trouble, have gotten bolder, and have had more avenues to get into trouble. We've all seen it. And not only as a judge have I seen this, as a mother of 3, I have seen it. And it's something that, as a mother and as a judge, I am frightened of. But our courts have been proactive. Years ago, the judges at the Court of Common Pleas determined that truancy was a major issue. They were looking at juvenile offenders and finding that most often they had been truant. And so as a result of that, we started a truancy program here in Lackawanna County, the STARS program. My court was the pilot office for that program. We actually, as judges, go into the schools to hold the truancy hearings. I myself go to Scranton High School and Northeast Intermediate on a regular basis, at least once, sometimes twice a month. And we're not just looking at the truancy, but at why the truancy. Before the family even gets into the room, the makeshift courtroom in the classroom, we have them fill out a form. And we determine, with the help of many professionals, mental health professionals, drug and alcohol professionals, children and youth professionals, we determine what the root cause of the problem is. So if we find out that the child is missing school because mom has a drug addiction, we order some intervention for mom right there on the spot. If we find that the root cause is that the child has a mental health issue, we order the treatment right there on the spot. So the courts have been very proactive in the area of trying to steer juveniles away from getting into trouble. The other area that is a big issue for juveniles is retail theft. As I said, I started a retail theft offender program. I started that program because when I was still in law school, I worked for Governor Casey in the Office of General Counsel and saw how a simple retail theft, stealing of a pack of gum, could ruin someone's life. It can keep you from getting certain certifications. So I started that program to steer juveniles away from offending, and it requires 6 weeks of counseling to determine what the issue is and to try to solve the issue. So I think the courts have been proactive in trying to resolve what the issues are. I think computers and telephones and all those things have certainly lent themselves to making it easier for juveniles to get into trouble. And I have ordered them removed. I have had them taken away from the children when they've gotten in trouble for such things. So I think the courts have been proactive. They continue to be proactive because we do have a growing epidemic of juvenile offenses in this country.
Thank you very much. Before we leave the area of the role of the judiciary in crime prevention, I think the public would just very briefly like to hear your views on the effectiveness of the sentencing guidelines, particularly mandatory sentencing guidelines that have been debated and disputed for quite some time. So I would ask, we'll start with Attorney Kelly, and perhaps just very briefly your view on the effectiveness of sentencing guidelines, particularly the mandatory sentencing guidelines that are imposed by our legislature for certain crimes.
I think sentencing guidelines have been a good thing in general. I've never really been quite in favor of mandatory sentencing guidelines because I think we have to get to the root and cause of why do we have the crime? Why is the individual in the criminal justice system? There are some individuals placed in the criminal justice system who are going to be hardened criminals, and for those people, maybe a mandatory sentence is not such a bad thing. There are other individuals that really, they're there because they made a mistake. Those are people that we can re-educate and rehabilitate, and for those people, a mandatory sentencing guideline doesn't necessarily work. Oftentimes, someone like that's put into a facility, incarcerated in a state prison or what have you, and that person becomes more the hardened criminal and never would have become so had it not been for the mandatory sentencing that he received. Therefore, again, I'm not necessarily in favor of mandatory sentencing guidelines across the board. I think we have to look at each case on an individual basis. I think the overall goal of the system should be to rehabilitate, not simply to put someone in the prison and throw away the key. Again, there are people that, yes, you're going to have to put them in jail. You're going to have to put them in for whatever the sentencing guideline says that they should be in for. Those people you're probably not going to rehabilitate. But I believe most people who find themselves in the criminal justice system can be rehabilitated, and I don't think a mandatory sentencing guideline necessarily serves those people.
Thank you, Attorney. Attorney Reeder?
Thank you. One of the driving forces behind incorporating mandatory sentencing guidelines was the need or the desire to have predictability and to send a signal to the public that if you make the decision to have behavior that acts outside of the law, you can expect these consequences. And so that was the driving force behind, one of them anyway, behind the sentencing guidelines, to encourage and allow for predictability. But one of the effects that mandatory guidelines has is that it takes the flexibility away from the judge when there are mitigating circumstances. Now, there are some provisions within the sentencing guidelines for the judge to take into consideration certain factors, but in large part, what the mandatory sentencing guidelines do is take that flexibility away. So the judges are constantly doing a balancing act. What is more important to society? Predictability, knowing the consequences of your actions, or flexibility for the judge. And I guess it depends where you're sitting, because if you were a defendant being sentenced, you would hope that the judge would have some flexibility to temper justice with mercy, and the sentencing guidelines take that away. And our goal should always be rehabilitation, and I think we could probably all agree that mandatory sentencing guidelines can, in certain circumstances, take away from the goal of rehabilitation because we're focused on predictability.
Thank you. And Attorney Farrell.
I think that mandatory sentencing guidelines do take away the flexibility that a judge may have, but I also think that here in Lackawanna County, District Attorney Andy Jarbola and his office have done a very nice job of working around and within the confines of mandatory sentencing. I say this because of plea bargaining, and often mandatory sentencing is only an issue if it's not been removed. There are many defendants charged with crimes that require mandatory sentences, such as weapons violations. But it provides an extra hammer, if you will, to the prosecutor so that when faced with someone who has this charge, who is probably more likely than not someone who could be rehabilitated, they can take it out of the equation as a plea bargain, which helps move the system along, which helps save on court costs, which helps save on prosecutor time, which helps save on judge time. Taking a mandatory sentence off the table is a great way to get a defendant to plead guilty. So while I do agree with what people have been saying here. Mandatory sentencing removes flexibility. In another way, it adds some flexibility because it allows the prosecutors to use it as a bargaining chip. But I agree that we need to have a lot of temperance of sentencing, that there should be mercy at the courts. I am a very merciful judge when it is appropriate, but it's not always appropriate, and that's why the sentencing guidelines are very helpful.
Thank you very much. All right. Lee, the next question is going to be...
Don't I get to answer that question?
Oh, I forgot. Of course. Sorry.
You know, when I first came to the bar in 1982, there were no sentencing guidelines. So I've had the benefit of practicing at a time when there were none and when there are some. And in comparing the two, there are arguments in favor and there are arguments against. The arguments in favor of it is what Patty alluded to, is that you have predictability. So if somebody robs a bank in Scranton, Pennsylvania, they're going to get the same kind of sentence as somebody who robs a bank in San Francisco, California. On the other hand, what it does do is it removes a lot of discretion from the judge. And the Constitution provides that the judge, the law provides that the judge is the one who imposes the sentence. The largest criticism that I have of sentencing guidelines is that it takes away a lot of the discretion from the judge and it puts it in the hands of the prosecutor. Because the prosecutor, by determining what the charge is going to be, is determining what that sentence range is going to be. And in fact, our United States Supreme Court about 7 or 8 years ago, held that the federal sentencing guidelines were unconstitutional for that very reason, was that it took the job of sentencing out of the hands of the judge, and that's where it's supposed to be. So they are no longer mandatory in the federal system. They are advisory. The judges are not obligated in federal court to follow the sentencing guidelines. In the state court, they still are. So you know, I don't think the Pennsylvania Supreme Court has addressed that particular question yet. But I do think there are pluses and minuses to the system. But as a judge, what I look at in wanting to sentence a person, I look at that person. I don't concern myself with what somebody in San Antonio, Texas is getting for that crime. I'm looking at the person that's in front of me. What's their background like? What's their family like? How were they raised? And what's their criminal record like if they have one? And I take all of that into consideration before I impose a sentence on that person for that crime. That's the way I look at it.
Thank you. All right, I believe the next question, if I'm right, goes to Attorney Reeder. We'll begin with Attorney Reeder. And we're going to shift focus a little bit and address the disciplinary system we have in place for the lawyers and the judges now. And given the recent negative publicity and public outcry over the unfortunate situations in the Luzerne County judicial scandal, the recent conviction of Supreme Court Justice Ori Melvin and the Lackawanna County Family Court Program, what I'd like to hear is your view as to whether or not the current system that we have in place for disciplining lawyers and judges is effective, and what, in your opinion, can or should be done to either improve that judicial disciplinary system, or more importantly, to educate the public on the disciplinary system that we have in place right now for judges and lawyers?
One of the things that we have to keep in mind as members of the bench, members of the county bench, the minor judiciary, attorneys, we operate under a very unique standard, improper conduct and the appearance of impropriety. And both of those actions, improper conduct or the appearance of impropriety, result in the same thing: lack of public confidence in the judicial system and in the judiciary. So that's what we're trying to avoid. Does our disciplinary system measures work for attorneys and judges? We could probably do more, but in light of the current scandal in Luzerne County, we do see that judges have been removed, they've been incarcerated, and of course that means that you lose your license to practice law. The public is much more educated today because of the internet, because of access to television, and so the public is more demanding on the judiciary. And the public wants judges and lawyers to be held accountable for their actions, just like members of the judiciary expect society to be accountable for their actions. So the public is really speaking, and they are demanding that our court system hold judges and lawyers more accountable for their actions. And that's a good thing, because like I said, we operate under a standard of not only improper conduct, but the appearance of improper conduct.
Thank you. Attorney Farrell?
I think that we need to be concerned with the behavior of everyone in the courthouse, from the judges on down. And I think that happens if people care. When I told some people I was going to run for judge, they said, boy, that's a tough race to get into, because people don't really care who their judge is. Now, when over 400 people showed up at my kickoff, I thought people do care, and that gave me hope. Because if people don't care and people don't pay attention and people don't watch, then anyone, judges on down, can get away with unethical, improper, illegal behavior. So I think as a society, as a judicial community, as a legal community, we all have an obligation to care, to pay attention, to watch what's going on, and to use the system that is in place, which I think, if it is used properly, can be very effective. People have to be willing to be brave, to step up and report improper, illegal, unethical behavior. And if that happens, then I think the system works and it will take care of itself.
Thank you. Attorney Gibbons?
I mentioned earlier that I was appointed to the commission in 2009 to investigate the wrongdoings in the juvenile court in Luzerne County. One of the facets of our investigation involved looking at the body called the Judicial Conduct Board, which is the board that investigates complaints that are filed against judges in Pennsylvania. And their obligation is to investigate the complaints and, if necessary, file charges, disciplinary charges against a judge, at which point that charge would be heard in a body before a body called the Court of Judicial Discipline. When we were looking at what was going on with Chivarella and Conahan in Luzerne County, we discovered that a complaint had been filed with the Judicial Conduct Board about Chivarella and Conahan. It was a very detailed complaint and was about 17 pages, and yet it never came to light. It sat on a shelf, and the Judicial Conduct Board never did anything about the complaint that it received. It was the U.S. Attorney's Office that wound up prosecuting Chivarella and Conahan and putting them in jail. The system that was in place through the Judicial Conduct Board did very little about the complaint. And as a result of that inaction, these guys were allowed to sit on the bench for much longer than they should have been, and continued to plague the juvenile justice system in Luzerne County. So as a result of what we found and our investigation, we made a series of recommendations regarding reform of the Judicial Conduct Board, and many of those recommendations have been put into place. The guy who served as the chief counsel to the Judicial Conduct Board is no longer there, and there's more public-friendly aspects to their website. The public can access and find out how to go about filing a complaint as a result of our recommendations. There's more transparency. You have before this, you couldn't find out how many charges were filed against judges and what happened with those charges. So there's more transparency with that and more accountability. You know, the system is only as good as the people who populate it, but you can also put into place checks and balances within that system to make it a whole lot more effective, and that's one of the things our commission accomplished.
Attorney Kelly.
Lawyers and judges are governed by rules that don't apply to the public in general. Lawyers are governed by the disciplinary enforcement rules, judges by the Code of Judicial Conduct. By and large, I think the system as it currently exists after being reformed does work. I think there's a perception on the part of the public, however, that it's an inside game and that the individuals who enforce the various rules and regulations against lawyers and judges are insiders. They're also lawyers. They're also judges. And therefore, when a lawyer should be disciplined, when a judge should be disciplined, it doesn't happen. I mean, in the past, that may have been true. It does. As the system works now, the discipline does occur and it does stick. However, I still think there's a perception on the part of the public that it's a closed system. So I think the problem with the system, if any, really is the lack of openness to the public. And not so much in the sense that the information isn't there for the public to find if the public wants to look for it, but the public doesn't realize how accessible the information has become since the various reforms with the system. Therefore, there should be a concerted effort made to educate the public that, yes, if your lawyer is subject to discipline, if a judge is subject to discipline, you can find out about it. You can see what was done in reference to that lawyer and that judge and the conduct that was allegedly deemed to be improper. I think if you make the system more open and transparent to the public, you restore confidence in the system, and the whole justice system is better served for all of us involved. The lawyers, the judges, and the members of the public.
Thank you. I believe it goes to Attorney Farrell now. Our next question, we're going to shift focus here, and I'd like to discuss equal access to justice. I was reading some census statistics, that's not my word, And more than 57 million Americans, 1 in 6, were financially eligible for legal assistance based upon their poverty level incomes. And this is an increase of about 3 million people since 2008, when the recession began. Recent editorials in our paper have suggested that our Lackawanna County Defender's Office is inadequately funded to properly represent the large amount of indigent criminal defendants we have in our county. On the civil side, we have Lackawanna County Pro Bono, Inc., which provides free representation to our civil litigants through our volunteer attorneys. They likewise are underfunded, and from Sylvia Hahn's estimate to me, bursting at the seams with requests for representation. My question to the candidates is, what in your opinion can be done to provide better, wider, and more equal access to justice to our citizens? Attorney Farrell?
Well, more money would certainly help that problem. I think everyone agrees that the Public Defender's Office is underfunded and that legal aid is underfunded, and that there are many people who deserve representation who cannot get legal representation. We have a wonderful organization in Lackawanna County, the Lackawanna County Pro Bono, which does provide for free legal assistance to civil people in civil matters, but they don't have enough manpower to handle the overflow. So there needs to be more funding, but that's not really the issue for the judge. Judges don't get involved in funding. Where a judge can help, and where I see it on a regular basis, is you can help shepherd a pro se defendant or a pro se litigant through the system. Now, the matters are small at the minor court judiciary, but often we see people come without lawyers. And so it's just important to balance the person's right to counsel, which they don't always have, with following the rules and making sure that they follow the rules. So without proper funding, a judge needs to keep in mind that justice must be served, and sometimes has to step in and help shepherd people through the system.
Thank you. Attorney Gibbons.
I think on the civil side, you know, what a judge can do is encourage members of the bar to participate and volunteer their time. Lackawanna Pro Bono receives limited funding, but what it does do is it calls on members of the Lackawanna County Bar to volunteer their time and represent people on a regular basis. I do it all the time, and it's a great deal of, it provides a great deal of satisfaction to these people who can't afford a lawyer in civil court, but they do get to have representation. And I think it's great for them, it's great for the bar, because it helps put a good face on lawyers, and Lord knows lawyers need a good face put on them as frequently as they possibly can. On the criminal side, it gets a little bit more difficult, because when your liberty is threatened, you have a right to counsel. It's constitutionally guaranteed. And so you have this problem with our public defender's office, is they're overworked and underfunded and understaffed. So it's not always, you can't really take somebody who's looking at, you know, a third-degree misdemeanor or a first-degree misdemeanor or a felony, and try and help them through without the advice of a lawyer. You have to, I think, do whatever you can within the system, and there's no simple answer for that. It does come down to funding. But if these people don't have lawyers, you can't make them go to trial without the advice of the lawyer in violation of their constitutional rights. So it is a funding problem. I think the courts can work with the funding authorities, in our case, and the county commissioners, you know, to try and free up more money somewhere in order to funnel it into the public defender's office. But that's the critical side of it. I think on the civil side, you know, Sylvia Hahn will tell you that, you know, she gets great support from the bar, from volunteer attorneys every year. And what they do is they'll give lawyers an opportunity to get free continuing education back in return for their time that they volunteer. It's the criminal side that's the real problem.
And maybe Attorney Kelly and Attorney Reeder, since the magic word here appears to be funding, and Jimmy mentioned the magic word, the funding authorities, perhaps maybe you can just let the audience know whether or not, what is your opinion as to who the court system can go to in terms of encouraging additional funding for pro se litigants, indigent litigants? The numbers continue to increase, and we have a staggering number of people that are eligible for free legal assistance. They just can't afford it. And that, as Jim and Alice have said, it ties up the court system because, as Jim said, you can't get a criminal defendant through the court system if they don't have a lawyer. And it goes back to funding. What is your opinion on where we can go, the court system, and who we can appeal to in terms of this cause and getting more funds for this greatly needed access to justice?
So, one entity that has not been mentioned tonight is legal services. We've heard a bit about pro bono. We've heard a bit about the Public Defender's Office. However, we've also had North Penn Legal Services in Scranton since the late 60s, when the Legal Services Corporation was first came into being. Legal Services Corporation is funded by the federal government, by and large by the federal government. We can attempt to approach the federal government about additional funding for legal services, for the Legal Services Corporation. I just read recently, this is very disturbing because I used to serve on the board of North Penn Legal Services. I was actually president at one time of it, but since its founding, it's had offices in Scranton. Recently, Legal Services, North Penn Legal Services is a consolidation of the legal services group in Wilkes-Barre, Scranton, Williamsport, and Allentown. They're leaving Scranton fairly soon. There's not going to be an office in Scranton. There was just an advertisement in the Lackawanna Jurist requesting someone to offer them volunteer space near the courthouse so they can meet with clients and shepherd clients to their hearings in the courthouse. It's simply we're losing them in Scranton because no funding. They're going to centralize an office in Pittston between Wilkes-Barre and Scranton. That's a matter for Legal Services Corporation and Congress to deal with, and that's where funding for the civil legal services can come from. In reference to Lackawanna Pro Bono, they were designed to handle the overflow that legal services could not handle. Lackawanna Pro Bono does an amazing job for the poor of Lackawanna County. It recruits volunteer attorneys, it assigns them cases, those attorneys are dedicated, they're hardworking, and the Supreme Court of Pennsylvania actually encourages each bar association to promote and sponsor pro bono programs. And the Lackawanna Bar Association does in fact do that, and in conjunction with Lackawanna Pro Bono, has done a good job in providing legal services to those who are indigent and deserve legal services. The trickier part comes in reference to the criminal defendants. As Jim noted, criminal defendants are constitutionally entitled to a lawyer whenever their freedom is involved. In terms of the Public Defender's Office, it's a matter of funding from the county, it's a matter of funding from the state, also possibly some funding from the federal government. And I think the judiciary, oftentimes in conjunction with the commissioners, has to work together to look for funding outside of the county itself, funding from the state, funding from the federal government. You simply can't tell a criminal defendant, I'm sorry, we don't have enough funding to provide a lawyer for you, you're going to have to go to trial without a lawyer. That individual, by the Constitution, by the Sixth Amendment of the Constitution, is entitled to a lawyer. Now, the fact that one may not be available now simply means that the whole criminal justice system begins to back up. He will get a lawyer at some point. However, that individual may remain incarcerated while he's waiting for a trial. That's not right either. What we do...
Thank you. Attorney Reeder?
Thank you. Clearly, the one thing that we all agree upon is funding. In order to make programs work, they need to be funded. And that's a fact. And we realize that in Lackawanna County because I think everyone agrees that the Public Defender's Office is underfunded. As a judge, our role is typically not to be a fundraiser, and we're given a budget by the county, and we have to sort of make our programs work within that budget. So we don't have a lot of places to go for funding. We go to our own county, we can go to the state, we can go to the federal government. But one thing that we did do in Lackawanna County was we did try to secure grants, particularly for the alternative or the treatment courts. And we did get some funding for those programs. So grant writing is an option, particularly for the treatment courts. And we found that to be very useful, and that does relieve the burden from the county to fund those programs. But like anything, you know, what's most important to you is where you put your money. And another area that we can assist in as a judge is just to constantly educate the public so that there is an appreciation for the seriousness of the role that the public defender plays. Because, like Tim said, the Constitution does provide for representation for certain criminal defendants if you cannot afford your own lawyer. So that's a fact. And we have to educate the public so that they have an appreciation for that. And in civil matters, even though you're not always entitled to a free lawyer, it's still a matter of educating the public, because we in family court or whatever court you're presiding over, civil court, we may see 20 cases a day, but for that litigant, for that individual, their case is the most important case. And so, of course, they want to have legal representation at this critical time in their own case. So educating the public is very important. Another area that we have done in the county court, particularly in family court, is developing forms so that if someone comes in and they're not entitled to a free lawyer, we try to make it as easy as possible for them to get through the system with forms that can be filled out, and it's just a matter of filling in the blanks so that they can at least get their day in court and get the case started. So those are some of the things we've been doing on the county bench.
Thank you very much. Excellent. And our last question, and we'll start with Attorney Gibbons. And we don't want to leave the audience or the public with the idea that it's all bad news here for our court system, because frankly, although the costs of judicial administration have skyrocketed, in response to the recent rise in costs, our legislature and our court has initiated various mandatory mediation and alternative dispute resolution programs and settlement efforts for civil cases to move the dockets along. Additionally, in our criminal area, our Lackawanna County has taken the lead on the specialty treatment courts. And in our family court arena, like Attorney Reeder has indicated, we have established programs as custody masters and the guardian ad litem program, which has been implemented to assist families in crisis and to resolve their disputes outside of the costly and adversarial system. And to end this program tonight, I would just like to ask each of you very briefly to kind of give us your vision for the judicial system. What, in your opinion, has been the success of these alternative dispute resolution programs, and what changes would you advocate, and what methods would you institute for improving any of our court procedures and the efficiency of the administration of our justice system? Attorney Gibbons?
I think the advent of the alternative dispute resolution programs, such as mediation, arbitration, helps people, helps the litigants get a much quicker resolution to their claim. Right now, in certain courts, if you are certified and ready to go to trial, you can wait upwards of longer than a year until you actually get into the courtroom before a judge and a jury. Mediation, arbitration, you can get in front of a special trial master or someone else and get a potential resolution to your case a whole lot faster and a whole lot cheaper. Litigation is very, very expensive these days. And so you have time and you have expense and you have uncertainty as to, you know, when you're actually going to get into the courtroom. So I think the advent of these programs has done a great service, not only to the courts in lightening the caseload, but also to the litigants and bringing a quicker resolution to their claims. And I think the same thing holds true with the specialty courts, the drug court, the DUI court. Those are peeled out of the normal criminal docket, and they're handled differently, but they're handled more expeditiously. And it's very similar to what Patty was talking about before with the status court, with the drug court. You know, you are under constant supervision by a team of people, not only a judge, but you've got probation people, you've got drug treatment people, you've got all kinds of people that are monitoring you on a regular basis. So that takes care of that. In terms of something to improve it, I'm a big fan of individual calendaring for judges. When a case comes in, it gets assigned to a judge right away. Right now, you don't get assigned to a judge until the two lawyers basically certify that the case is ready to go to trial. In the civil side. In the criminal side, you're either going to get assigned to Judge Perez or Judge Giraldo. But when the judge takes the case from the beginning, the judge has a vested interest in moving that case along and bringing it to a quicker and more expeditious resolution for the litigants themselves.
I believe the family court arena has sometimes adopted this where one family, one judge, so that whenever a family comes, you don't have to re-educate the judge as to the history of this family, and I think that has worked well as well. Attorney Kelly, do these programs work, and is there any changes that if you were elected judge you would like to implement?
Oh, I think the programs certainly work. In the civil system, the statistics are telling. In the last year for which we have statistics, of all civil matters that were resolved and disposed of, only 1.2%, I believe, were disposed of by a trial with a jury. And that's significant because jury trials tend to clog the system. There are only so many trial weeks per month that you can sit and hold a trial term. Cases that go to trial anymore are not the cases that went to trial 30 years ago. They're not the case about who had the red light or who had the green light, or was there a defect in the sidewalk that someone tripped over. They're much more complex. They're medical malpractice cases. They're products liability cases. These are not 2 or 3 day trials. One of these trials can take up an entire trial term, which means every case behind that case doesn't get heard, and it just moves the system back a bit further. The various alternative dispute resolution matters impacted and enacted by the court system have served to move those cases through the system much more quickly. The cases are assigned to a trial master. The trial master can conduct a trial in place of the judge. He can conduct it in an expeditious manner. The court also has a mediation system, and there's a mediator that the court can appoint to sit down with the litigants, and he'll spend as much time as you want trying to move your case through the system and getting everyone to come together and settle the case, which really is what the goal of the civil system is, to get the case settled and moved through the system. These things have worked in the civil system. In the criminal system, the trial backup was never as bad simply because we have a constitutional mandate for a speedy trial. In the criminal system, though, you can still have some backlog occurring because of the matters that are handled by the specialty courts. And the specialty courts have really done a good job in moving the DUIs, the drug issues through the system, and allowing for more time to be spent by the judge on the more serious criminal matters. So those work. I agree that we should have an individual calendar for judges. It works in the federal system. As long as I've been practicing, that's been the system in use in the federal court. You know from roughly a month after you file the complaint in the federal court who your judge is going to be, and that judge takes charge of the case. He shepherds it through the system. He sets deadlines. He'll tell you at the first conference when your trial is going to take place. And he'll hold you to those deadlines as it moves through the system. I think the individual docket works. All these alternative dispute resolutions also are grand cost-saving measures. It's very expensive to try a case anymore, not only for the court system, but also for the individual litigants.
Thank you. Attorney Reeder, you have practiced extensively in the family law area and the criminal. The new programs that have been instituted to assist families in resolving a crisis, any changes that you see just based upon your experience that you would implement if you were elected judge?
Particularly in family
I would
court,
think
or?
so, particularly.
Okay.
We've heard from Jimmy and Timmy regarding the civil and the mediation, arbitration. And with your background in the family court area, I'm sure the public and the audience would be interested to know what your opinion is on the success of the programs that are in place now, and if you would recommend any changes.
Okay. One thing I will mention, we are doing a lot of great things in Lackawanna County on the county bench. One of the items that was not mentioned that is relatively new to the county bench is the implementation and the hiring of a discovery master. We know that in civil cases, where cases sort of get snagged and held up is over discovery disputes, depositions and interrogatories, and the constant going back and forth of that. We now have a discovery master in Lackawanna County whose sole function is to assist in the resolution of those discovery disputes, and so that moves our civil cases along much further. The treatment courts that we're utilizing in family court are particularly two that come to mind: intensive reunification court, which deals with families who have children who have been declared dependent, meaning that those children we've conducted a hearing and we've determined that the children are either abused and or neglected and without proper parental care and supervision. There's a variety of standards. Once we declare that child dependent, they can qualify for a court that's called intensive reunification court, and those cases are reviewed weekly. And having a weekly review does a lot of great things for the family, because they are coming in weekly and they are responsible to the court, and the court can check up on the programming that was put into place and make sure that it's working. And if it's not working, we have to try something else, and not review these cases every 90 days like we had been doing in the past. We're looking at these families weekly, and we're able to implement and oversee change in the family, because the goal always is to return the child if we have to remove the child from the home, because we know they don't want to be removed. If we have to keep the child safe, our goal is to get the child returned back to their family as quickly as possible. And that's what we're striving for in intensive reunification court, and that's been working very effectively. Status court is also an alternative court, and that again provides weekly reviews where the juvenile is coming in and answering to the court weekly. How's it going? Are you making progress? If drug addiction is the problem, are you making progress with your drug counselor? How's school going? Are you attending school every day? They're letting us know weekly if they're in school, not 90 days later. Oh yes, I've missed the last 2 months of school. So the treatment program courts are working very effectively in Lackawanna County, and it truly is a credit to Lackawanna County and the entire bench.
Thank you very much. Attorney Farrell?
I think that the treatment courts are the best thing that have happened in Lackawanna County. Judge Barace's drug court is a wonderful invention. I have had defendants whom I have arraigned when they are still drug sick come back to me after their graduation from drug court to say, thank you for your kindness when you arraigned me. Thank you for locking me up when you arraigned me. And look at me now. I went through drug court and I successfully completed it, and I just graduated. So I think that the treatment courts are working very well. I think the Veterans Court is going to work very well. I think the Mental Health Court is a great asset to this county, because we don't have enough funding for mental health patients. And often criminal matters arise because of mental health issues. And they're people who don't deserve to be locked up in the county jail, because their issue is not that they are a criminal, but that they are mentally ill, but their mental illness causes them to act out with criminal behavior. So I think that the treatment courts have been very effective. I think that masters and mediators have their place as long as the parties agree to them and they are helping to move the system along. I think that the judges who are elected by the residents of Lackawanna County need to make sure that the masters and the mediators are held accountable. And that's the only caution I would have as far as those people are concerned.
Okay, thank you very much. That concludes the formal question and answer session that we have prepared. We have a little bit of time. I'm looking at my watch, and we have about 5 minutes. So I would open the floor to any questions from our audience here to the judicial candidates. I would note my warning to you in the beginning that they're not allowed to discuss any disputed political or pending cases. So your questions would have to be in line with that parameters. But if there's anyone in the audience here that has a question that they feel we haven't addressed and you would like to bring to the attention of the candidates? Everybody's satisfied with our court system then, right? Okay, great. Well, on behalf of the Federation of Lackawanna County Democratic Women, I want to thank Attorney Farrell, Attorney Gibbons, Attorney Kelly, and Attorney Reeder for taking time to hear. And I am just very impressed with our candidates, and I hope that you are as well. I truly believe that Lackawanna County citizens are very privileged to have 4 outstanding candidates for a judicial seat here. I think they have demonstrated tonight a very high level of competency, knowledge, and understanding of our court system, and I think their dedication to our court system is just very, very impressive. So good luck to all of you, and I would encourage everyone here and in the public to vote on May 21st. Thank you, and good evening.